In 1975, the Texas legislature passed a law that withheld funds from schools for the education of illegal immigrants. The law also allowed schools to deny enrollment of immigrants who could not produce paperwork to support lawful entry into the United States unless they paid tuition for their schooling. These are the plaintiffs. 16 students from Tyler Independent High School who could not produce the proper documentation and therefore were not allowed to attend school. MALDEF, Mexican American Legal Defense and Educational Fund, are representing those 16 students from Tyler Independent High School. They claim that the law violates the Equal Protection Clause under the 14th Amendment. They seek to have the law reversed. Here is the defendant, John Plyler, superintendent of Tyler Independent School District. He, along with Texas legislators, argue that illegal immigrants are not within the jurisdiction of the state and thus cannot claim protections under the 14th Amendment.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants in our forum, the People's Court.
Welcome to Calaluche's Court. Justice William Brennan will be presiding over the court. Today, we will be deciding the case of Plyler versus Doe. This case has already been heard a couple of times. The first hearing was in the U.S. District Court, in which Judge William Wayne Justice sided with the plaintiff and stated that schools could not keep undocumented children from receiving a public education. The state of Texas was not happy with this result and therefore appealed. The case eventually reached the U.S. Supreme Court on December the 1st, 1981. The decision will be reported today, June 15th, 1982. This case raises the issue of the Equal Protection Clause, which states, "No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The defendants claim that because the immigrants were there illegally, they should not be considered persons within the jurisdiction. However, the U.S. Supreme Court found that no other cases nor the 14th Amendment were supportive of such limited definition of within the jurisdiction. The Supreme Court stated that the provisions awarded by the 14th Amendment are universal in their application to all persons within the territorial jurisdiction, without regard to any differences of race, color, or of nationality, and the protection of laws is a pledge of the protection of equal laws.
A decision has been made. Undocumented children of alien parents cannot be denied a public education. The Texas law must be reversed.
The U.S. Supreme Court found that the spirit of the 14th Amendment was to protect anyone who is subject to the laws of a state. The presence of a person within a state, regardless of how he or she got there, entitles him or her to the protection of the laws that a state may choose to establish. The court also claimed that these children do not have control over where they live and should not be discriminated upon because of their parents' unlawful entry into the United States. Mr. Justice Brennan stated that education has a fundamental role in maintaining the fabric of our society. Mr. Justice Brennan stated it is difficult to understand precisely what the state hopes to achieve by promoting the creation and perpetuation of a subclass of illiterates within our boundaries, surely adding to the problems and costs of unemployment, welfare, and crime. It is thus clear that whatever savings might be achieved by denying these children an education, they are wholly unsubstantial in light of the costs involved to these children, the state, and the nation. If the state is to deny a discrete group of innocent children the free public education that it offers to other children residing within its borders, that denial must be justified by showing that it furthers some substantial state interest. No such showing was made here. Accordingly, the judgment of the Court of Appeals in each of these cases is affirmed.
Now, outside the court, we will interview Judge C.J. Berger, who had a dissenting opinion. He claims that the court abused the 14th Amendment in an attempt to make up for Congress's lack of effective leadership in dealing with the immigration problem. He claims that it is not the court's responsibility to set the nation's social policy. Judge Berger, can you please share your thoughts on this?
I fully agree that it would be folly and wrong to tolerate creation of a segment of society made up of illiterate persons, many having a limited or no command of our language. However, the Constitution does not constitute us as Platonic guardians, nor does it vest in this court the authority to strike down laws because they do not meet our standards of desirable social policy, wisdom, or common sense.
Thank you, Judge Berger.
The landmark decision in Plyler v. Doe has opened the door to an education for many, many children over the last 31 years who may have otherwise been denied an education. Yet today, the decision is still under fire and continues to be challenged by other states. A similar law was voted upon in 1994 in California, Proposition 187, which established a state-run citizenship screening system that had prohibited illegal immigrants from using health care, public education, and other social services in California. This law was struck down days later due to its unconstitutionality. In 2011, Alabama enacted HB 56, a bill that requires schools to check immigration status of students enrolling in their schools and to report their findings to the INS. This bill has been temporarily blocked in the federal court. For now, courts have supported the Plyler v. Doe decision and continue to guarantee all students the right to a basic education, regardless of immigration status.